everything 2020, it's the dichotomy of two worlds, two polarizing sides, those who want to reopen and those who want to continue shut down. As always, the middle ground seems to be the most complicated to find. Joining me to talk about all things law is defense attorney and political commentator Vikas Bajaj, all the way from California. So good to see you, Vic. All right, let's start in Wisconsin. You see the Supreme Court here ruling with this conservative legislative body, agreeing with them, saying that, yes, the governor of Wisconsin, in fact, did overreach in extending this stay-at-home order. How do you interpret that?
Well, first you have to look at the actual language in the decision, and rather than saying, well, you know what, the state had it wrong in principle, the Supreme Court of Wisconsin was tasked with the unique opportunity to look at how it was implemented. And in this case, the authority was not through the governor's office, so there was sort of a technicality that was seized upon, and the Wisconsin Supreme Court said, well, you know, you can't do it that way. Now, importantly, aside from that distinction, the dicta and the language by the Wisconsin Supreme Court reiterated the extraordinary steps that the government must go through when they're constraining citizens' rights to, for instance, assemble or to practice their religion. So by no means was this a victory of any sorts with a camp that wants to sort of keep things staying at home. It was more of a victory for those that want to open the economy up. And you see this type of action taking place all over the nation. We have rumblings starting here in our fine state of California as well.
Yeah, and you touched on something that's important here. It's a technicality. It's a loophole. And again, every jurisdiction has its own code, its own laws. And that's exactly what happened in Wisconsin. In essence, everybody, with the exception of Milwaukee and Madison, it's a free-for-all. There's no rule about masks. And if there is, you can't enforce it criminally. That's what happened with this agreement from the Supreme Court in Wisconsin. But then you look at state law. And obviously, Wisconsin's one state, and the rules there don't apply to other states. But Supreme Courts, they do look to other Supreme Courts to see how they ruled. You were talking about California. You have the instance of Los Angeles. Mayor Eric Garcetti there unilaterally also extending this stay-at-home for essentially 3 months. Could you see something similar there where there's an emergency injunction, it ends up at the Supreme Court, and all of a sudden it was overreach?
Well, it's already in play. And to your point, it's not only California here. And when the governors of any states say, well, there's no end in sight, or I'm going to extend it for 3 months, what that does is it opens the door for factual investigation. And when you use the term injunction, so, Marina, that is a request to have a court order the state to stop something, in this case, for instance, the stay-at-home order. Now, what appellate courts do and Supreme Courts of the states, as well as Supreme Courts of our fine country do, is they look at data. And the data is going to be what's going to be parsed through and is going to give a victory to one side or the other. Unfortunately, as more time goes on, we can see the data coming through. I'll just use San Diego as an example. Unfortunately, for those souls and their families, we have upwards of 200 people who have died from COVID-19 related illnesses. However, the data just came out last week that said there were only 6 of the over 200 that were singularly caused by COVID-19. So these are the types of data and research and analyses that the local federal courts will use, meaning the district courts, and then the appellate courts, and then finally to the United States Supreme Court. The facts may not help the push to keep things locked down, and surely not for predetermined dates and durations such as 3 months like we have here in California, in Los Angeles.
We could talk about this all day because I know that Colorado also revised their data and they're looking at those numbers and they've changed dramatically. Let's move on here, Vic. Let's talk about something that is somewhat COVID related. You have this group of senators on the Intel committee who dumped their stocks very quickly after they learned that this pandemic was headed our way. And in particular, we have Senator Richard Burr of North Carolina, who just last week, a warrant was issued at his attorney's office for his cell phone. The FBI goes to his house here in the Washington area. They pick up his cell phone. And something that's interesting to me, because the investigation, according to these allegations, I think is warranted. But you look at the due process here. I'm curious about your take. When you compare something like, say, the Paul Manafort case, where they go to his house, they raid his house, and we know what underwear this man was wearing. We know that he had an ostrich jacket, and yet they go to Richard Burr's home, and they ask politely for the cell phone. Nothing else is seized at the house. Nothing else is searched for. It seems weird.
Well, weird is probably the most accurate and probably the nail on the head term to use. I can just encourage all of our viewers to go back chronologically. The departments that are at issue here, the Department of Justice, which is the umbrella organization that controls the FBI, of course, is a whole different breed now than it was under prior leaders of the FBI, for instance, James Comey. And so when you see the executions of search warrants, these are singularly and particularly within the jurisdiction of law enforcement, which means FBI. Now, I can tell you, having represented many individuals of different walks of life, it's very common for federal authorities to call my office and say, Mr. Bajaj, we're investigating your client. Can we meet with him or her at your office? Or can you have them meet us at your office and produce a laptop or a computer or anything like that? That's normally how it's done. Anything to the contrary is really there for purposes that are yet unknown. But it's not rare to have a phone call to an attorney and then a casual appearance at a person's house to obtain a search warrant. There's nothing untoward about that. Perhaps the interesting thing about it is it's a demonstrative example of the change in the tide on how the Federal Bureau of Investigation is doing their work now versus, let's say, a couple of years ago.
So they're sticking tight to the warrant. They're not using their liberties, is what you're saying, to search every crevice of this man's home.
Well, absolutely. And warrants, especially at this magnitude, when you can bet your bottom dollar, you'll have esteemed counsel that will go through that search warrant affidavit piece by piece, letter by letter, and line by line. You have to cross your T's, you have to dot your I's, and we would really have to be living in a hole to not understand that the discretion and the jurisdiction of the FBI are things that are extraordinarily more at issue now than before. So you'd bet your bottom dollar that the T's were crossed and the I's were dotted in regards to the probable cause for the affidavit, and things are being done by the book as it appears at this point in time.
And again, this COVID thing has really changed how we do all sorts of business, including the Supreme Court of the United States, which has largely still been very ceremonial and very like the old times. Oral arguments now by telephone. Even Ruth Bader Ginsburg, Justice Ginsburg at the hospital with that gallbladder infection, hearing those arguments. And I assume this is across the board and across the country.
Absolutely. I have federal cases across the nation, of course, in my own backyard here in San Diego, California. And the federal court systems have moved quite quickly, having already been on an e-file or an electronic filing system. What we have now is a jump towards allowing appearances and arguments, contested hearings being done over, different apps that would allow that kind of confidential communication to take place. The drawback of it is, well, the value of the fancy tie and suit isn't really there. We haven't seen how the effect is going to be for jury trials.
Right.
How do you try a case? And I'll tell you, throughout the nation, we've received emails from the court clerks saying everything is on hold in federal court until a date that we don't know yet for jury trials and grand jurors. The flip side of all of this, for instance, new pioneering area of technology and learning new things, which is always a wonderful thing, is the transparency. Now we have the ability to actually, you bring up the Supreme Court of the United States, we have the ability to listen in to these arguments now after they occur, to listen to see what the questions are that are being asked and, in fact, what the issues are, rather than, of course, relying on headlines. So the transparency is really the big winner with this technological change.
Have to be there in person. I wonder how this is going to change the 180-day clock that you have for the right to a speedy trial, but I guess that's a different conversation for a whole different other day. Vikas Bajaj, thank you so much. Always a pleasure.
My pleasure. Thank you.